All right. Thank you so much for joining us today. I am Katie Anderson. I am one of the owners here at Aperion, and we appreciate you guys joining us this afternoon. We do these board trainings on a regular basis in various different topics throughout the year. And we are very lucky to have Chris Tingley from Vile Fotheringham here with us today to join this conversation. Chris has over 2 decades of experience. Chris and I have worked together a long time in various HOA issues over the last couple of decades. And, he has represented HOAs all over the state, in other states too, because I think you are licensed in Utah and Idaho, and does work kind of throughout the Pacific Northwest. So thank you, Chris, for being with us today.
My pleasure. Thanks for having me.
And we are going to tackle a really kind of important, but can at times be a bit complex of a topic. And just a few sort of housekeeping items before we kind of get rolling. We do record these trainings so that we can use them up on our YouTube channel for the ability for our boards to listen to the trainings at a later date. So during the training, if you could keep your cameras off and your audio muted so that it doesn't disrupt the recording at all and we're able to utilize the content for future boards to observe, that'd be great. We will give you guys an opportunity at the end of our session to ask questions. So don't worry, we will make sure that you get an opportunity to ask questions of both Chris and I. But if you could keep cameras off and yourself muted during this time. We will also be utilizing the chat functions throughout. So if you have questions that come up throughout, feel free to utilize the chat, and Chris and I will try to address them through the training. So on to our subject matter today. We are going to talk about privilege, who essentially has it, what you need to know. Chris is going to cover some legal aspects of what attorney-client privilege really means. And this topic really has been something that has been percolating, I think, to the top of our more awareness or being more concerned about, because we are starting to see more litigation with clients. We're starting to see sort of an elevated amount of legal issues that are coming in front of boards. So we wanted to really tackle this, and we're really fortunate to have Chris with us today, who's going to go through some of the more dense legal side of this. And then we're going to sort of talk about some of the more practical operational issues that as a board you need to be aware of to maintain your privilege and to not get yourself into trouble if you do experience some litigation. So long agenda, a lot of dense information. Again, please utilize the chat if you've got questions, but we're going to dive in, and I'm going to turn it over to Chris to sort of kick off on what is privilege? We'll ask the question. We will not be afraid to ask the question. What is privilege?
Wow. Well, maybe too dense to get into, Katie, but I'll try my best and we'll go there. All right. So the attorney-client privilege is what we're talking about, and it is codified under Oregon law. It is also a rule of evidence and is contained within the Oregon rules of evidence. But the reality is the privilege only truly comes up in the course of a lawsuit and in the course of dealing with an evidentiary hearing. That's the basic parameter of it, but it has a lot of key components. So I've got the rule up here just so we can read through it and see it. And it's dense, like Katie said, and I'm going to read through all of these, and then we're going to go to the next slide, which breaks down the definitions and explains it a little bit. So here's the privilege. A client has a privilege to refuse to disclose and to prevent any other person from disclosing confidential communications made for the purpose of facilitating the rendition of professional legal services to the client. A, between the client or the client's representative and the client's law practitioner or a representative of the law practitioner. B, between the client's law practitioner and the law practitioner's representative or the client's legal referral service. C, by the client or the client's law practitioner to a law practitioner representing another in a matter of common interest. D, between representatives of the client or between the client and a representative of the client. E, between law practitioners representing the client, or F, between the client or a representative of the client and a legal referral service. So this very technical definition, hard to read, is dependent, like most things in the law, on what terms mean, what words mean, and what the definitions are. So let's go to the next slide and let's break it down a little bit. A client has a privilege to refuse to disclose and to prevent any other person from disclosing confidential communications made for the purpose of facilitating the rendition of professional legal services to the client. In other words, in plain English, a client has the ability to stop someone from disclosing the substance of a confidential communication rendered in receiving legal advice or received in receiving legal advice. Okay. But it then creates a different sort of question or a number of questions. Who's the client? What's the client? What's a confidential communication? Who's a law practitioner? Who or what is a legal referral service? Who is a representative of the client? All of these things beget different questions. And so this is defined again in statute and under the Oregon Rules of Evidence, Rule 503 spells it out. So a client can be a person, a public officer, a corporation, an association, including a homeowners association, or other organization or entity, whether it's public or private. So that's a client. It's the person who receives the legal advice. And we'll get more into depth in who actually qualifies for a client in an HOA context, but that's who a client is. Who's a law practitioner? Well, a law practitioner is a lawyer, someone authorized to practice law, but it includes, when it talks about a representative of the law practitioner or someone working with the law practitioner, it includes paralegals, it includes legal staff, it includes anyone in the lawyer's office that has communications with the client. A legal referral service is an entity that, as a regular part of its business, as it says down in D on the right-hand side of this screen, who refers potential clients to lawyers. So it's a referral service. And if you call, maybe you call the Oregon State Bar. The Oregon State Bar has a referral service. You call the bar asking for a lawyer. You tell them the story and what you need. That's a confidential communication, and they would qualify as a as a legal referral service. Representative of the client, it can be, if it's an individual, it can be the individual, him or herself. If it's a corporation or an entity, it can be a principal or a director or an officer of the client. It can be someone given authority to obtain professional legal advice. That might, in some cases, mean a manager. It could be anyone that's given that authority. So those are the key definitions, but I left one out, and I left it for last. Confidential communication. What is a confidential communication? A confidential communication is one that is not intended to be disclosed to third parties other than those to whom disclosure is required to further the client's legal needs. And so not all communications are confidential. Some we don't care if they're disclosed or not, and that's not a confidential communication, but only confidential communications are relevant and are bound by the attorney-client privilege. So those are the definitions, though, and that's the privilege. That's at a thumbnail, well, not a thumbnail, as the literal language, what the privilege is. But what does that really mean? Well, let's go to the next slide. What it means is that a person or a company has the right to communicate confidentially with a lawyer. And if somebody comes across that communication or tries to get that communication to come out, the client can prohibit the communication from coming out. The evidence is inadmissible in a court of law, in a hearing, in a trial without the client's consent. So you have a right to privately communicate with your lawyer, and any evidence derived from a confidential communication that's privileged is excluded from being used in court. The exception to that is that if the client submits the evidence or goes to use it in court themselves, that's not confidential. It's no longer confidential. Okay. That's the basic plain English gist of what the attorney-client privilege is.
Can you give an example of that, Chris? Like what would be a situation that a client would want to submit a confidential communication that would breach privilege?
Well, the most common is when there's a malpractice lawsuit against the attorney. So that's the most common. If the client then says, well, this is what they told me and the lawyer screwed up and I was harmed. Okay. That's the most common. But there are other situations where in an HOA context, maybe the HOA is being sued and the individual directors are being sued for breaching their fiduciary duties. And they say, no, we're relying on the advice of counsel. And so we want to use the business judgment rule to shield us from any liability. To do that, they would have to waive the privilege. They would have to waive and have the attorney testify as to what he or she said, and to testify that they advised them, right? First step is, yes, I advised them on this issue. And then, likely what the communication was. So that's a situation.
Okay.
Yep. All right, next slide.
This is just a little bit of levity.
Yeah. Psych, you're not protected. That shows you how old we are, though, Katie.
I mean, we'll have some more current jokes later on in the slide.
All right. Okay, so there are some exceptions to the current attorney-client privilege, and these are also codified under Oregon statute and in the Oregon evidentiary rules. Okay, there is no privilege under these 5 different scenarios. I'm not going to go through them all because they don't all apply to an HOA, but I'm going to go through the first couple of them just so you kind of see what the exceptions are. So first one is there's no privilege if the legal advice was sought by anyone with a plan to commit a crime or to commit fraud, and the client knew or reasonably should have known that it was a crime or fraud. So if you go in and you're getting legal advice to get around the law and commit a crime, there's no privilege there. The second one is any communication between 2 people or 2 parties who claim through the same deceased client the rights. And so this is typically seen in probate or in other estate planning issues. Somebody dies, and it can be an issue for a bit in an HOA because you might be trying to collect from somebody who's part of an estate, got an estate plan in place, and they might have a couple of descendants, and so you have to look, and you may have an angle where you get communications that otherwise you wouldn't get because there's no privilege between those 2 parties. The third one is the lawyer malpractice issue, right? A breach of duty by the lawyer or the legal referral service to the client, or importantly, we lawyers cover our backside sometimes too. If there's a breach of duty by the client. So it's not just a breach of duty by the lawyer or the legal referral service, but there's also a breach of duty by the client to the lawyer or the legal referral service. So it goes both ways. And then as a communication relevant to the issue concerning an attested document to which the lawyer is an attesting witness. So if I'm testifying about a document and I'm a witness, there's no privilege there. Most commonly, that's a will where we see it, but there are other documents that could come up even in an HOA context where if I'm testifying, there's no privilege there. So that's really the exceptions to the privilege. All right, next slide. So now we get to the nuts and bolts. Who can claim the attorney-client privilege? Well, if you're an individual and you're going in seeking legal advice, you can claim the privilege. You know, I hire a lawyer, I go in for myself, or I go in for my wife and I talk about our estate planning, or, you know, I'm a homeowner who wants to sue my HOA. I go in, I talk to the lawyer, I get legal advice about what to do and how to do it and what my rights are and options are. That's a confidential communication. Don't intend that to be disclosed, and I can claim it. Individually, I claim the privilege. But the rule also says that the privilege may be claimed by a guardian or conservator of the client, the personal representative of a deceased client, or the successor trustee or similar representative of a corporation, association, or other organization, whether or not in existence. So whether or not the corporation, association, or other organization is still around. So the privilege survives even the death of the entity. But that means a representative, like a director or officer, can claim it. What about the manager? Can the manager claim it? Well, the manager probably cannot claim it unless the board has expressly given the manager the authority to have confidential communications with the lawyer to discuss these things. Because the manager, although a representative of the entity, is one step removed, is not part of the control group unless there is especially given authority. So if we go back to the definition of what it says in the privilege, it says a client can prevent the disclosure of a confidential communication between the client or a representative of a client and the law practitioner. Well, the manager may or may not be the representative of the client, but to be safe, if I'm a board, I'm given and it's showing up in the minutes, the authority to have those confidential communications. That's the safe way to ensure that you're doing it. But there's no question that a director or officer of the corporation can claim the privilege. Now, what about the lawyer? Can the lawyer claim the privilege? Can I claim the privilege on behalf of my clients? And the short answer is yes, but the real answer is more nuanced. So if we continue reading the rule, it says the person who was the law practitioner or legal referral service or the law practitioner's representative at the time of the communication is presumed to have the authority to claim the privilege, but only on behalf of the client. So I can claim attorney-client privilege. I'm not answering that question based on the attorney-client privilege, but I'm not stating it for myself. I'm claiming it on my client's behalf, which means my client could say, no, I don't care. I'm waiving it. You can talk.
Mm-hmm.
Okay. So that's one thing that often gets confused in the attorney-client privilege is that both sides can claim it. And technically that's true. But when I'm claiming it, I'm not claiming it for myself. I'm claiming it on behalf of the client. Can't talk because it's privileged. Okay.
And beyond noting it in the minutes, Chris, so, you know, as far as like they have litigation going on, you know, noting in the minutes that the manager is either under the control group or that they are allowing the manager to have confidential communications with the lawyer. does it need to be a motion or does it need to just be an action, something noted in the minutes? What's your best recommendation around that to properly
No, I mean,
document it?
it needs to be a motion. You need to have a motion, a second, discussion about it, and then a vote, and then it goes in the minutes. Yes. You got to go through the whole process, and you've got to authorize them to do it. And we'll talk a little bit about some of the operational effects here in a little bit, and I'll tell a couple of horror stories. But that's got to be in the minutes that the manager is part of the control group and has the authority to talk to the lawyer and obtain confidential communications from the lawyer or with the lawyer. Okay, so
Perfect.
that's who can claim the privilege. Let's go to the next slide. To whom does the privilege belong? Okay, and I've already touched on this a little bit. Okay, so it belongs to a person. I walk into a lawyer's office, I get legal advice and have a confidential communication with the lawyer, I can claim it. Corporation, so a homeowners association in Oregon is going to be both a nonprofit corporation and an association. They can be two separate things, but in Oregon they're not really. But the corporation can claim the privilege. It belongs to the privilege, or it belongs to, excuse me, to the privilege belongs to the corporation. What about a representative of a client? This goes back to the manager. Well, it depends on who the representative is. Is it a director or officer? They can claim it, but again, they're claiming it on behalf of the corporation. Unless the advice is specifically given to the director or officer for that director and officer, that communication is, and that privilege is not theirs. It is the corporation's communication. It is the corporation's privilege. Same thing with a manager. A manager may be able to claim it, particularly if they go through the process we just talked about, but unless it's specifically directing or directed to the manager for the manager, it is not the manager's privilege. And that's an important thing to know. What about members of the association? Well, I look at the members of the association like I look at, I happen to own a couple of shares of Nike stock, not doing very well right now, but I am a shareholder of Nike. And so in a way, I am a member of Nike, but that doesn't mean I'm part of the control group. It doesn't mean that I am part of the group that gets to sit in the meetings with the lawyer and gets to sit in with the board of directors and figure out what's going on. My rights are limited, and a member of an association is just like that, just like me as a shareholder. They are members, they have rights, and there are certain things they can do, but they're limited, and they don't get the privilege. The privilege doesn't belong to them. Just like I am not their lawyer if I'm representing the HOA. I am the entity's lawyer. And so if I am visiting with an HOA client and I have a communication with Katie and maybe the president of the association, well, that's great for Katie and the president of the association, but the privilege is not theirs. The privilege is the corporation's. And so it can only be waived by the corporation. It cannot be waived by Katie. It cannot be waived by the president. It is the association's or the corporation's privilege. And the members of the association cannot upset that. They don't have a right to change it.
But I think it's important to understand that both, us as a representative for, an agent for the corporation and the board have a duty to be aware of the privilege that exists for the corporation, and do what we can to not compromise that. So while the privilege rests with the corporation and it isn't, the individual board members, think understanding that duty is also kind of important.
Yeah, and the last thing we're going to talk about this afternoon is the fiduciary duties of care and loyalty, and we're weaving those in because that goes to this whole idea of the privilege. So we got a question in the chat, Katie, from Sylvia. She was saying, is designating the manager part of the control group specific for a single issue, or can it be enacted to cover more widely? The short answer, like any good legal answer, it depends, right?
It depends.
But Yes, you can do it. I wouldn't do it, frankly. I wouldn't want to give the manager carte blanche, and no offense to managers or, Katie or any other manager out there. I would do it on a case by case basis. And I'm going to punt a little bit on the rest of this answer because we're going to talk about it here in a few minutes, but there's a reason behind that. And part of that reason is it's a contested issue. And I think Katie's got it going on in a case right now. I've had it in cases in the past about, well, is the manager even doing this? So, as I say, they're part of the control group. It's still possible that a judge might say they're not, right? It doesn't matter what you designate them. A judge is going to look at the factors, the behavior, and a number of different things like that to say, well, I know that's what you said, but under the law, they're not really part of the control group. And so
Mhm.
to mitigate that risk, I rather than blanket give the authority, I would do it for a single issue so that you're limiting your exposure to that single issue.
And I think the important thing to understand too is that it does kind of depend on the issue, because there may be things that you don't want your manager to be the one communicating with the attorney, and you want to keep them outside of that group and keep the communication between the attorney and the board. Because there may be some reasons that you don't want them to be deposed, or you don't want all that information to, even have to be discoverable. There may be some strategies behind that you need to have that conversation with the attorney that might be fact specific in what's going on. But our goal today is to even get you guys to kind of be thinking or understanding what this concept of privilege means, so that if you have a situation come up, you can talk about it with your manager as well as with your attorney and say, what's the best strategy given the facts around this case? And here's the work that has to be done to prepare us to answer or respond. Who's best to do that? And, how do we communicate through that process? Because I think just the awareness and asking the question is going to be like the first part of that.
Yeah. So, and first of all, I want to thank Aperion and Katie for inviting me to present today. But I have to point out, okay, as part of this discussion, one of the things that you need to understand is that when I am, Katie will call me up and ask me a question about a client, something that she's dealing with, that then I go and help later on. My duty of loyalty is not to Katie. My duty of loyalty is to the association. The association is my client, and that is who I owe my fiduciary duty to. And so the board, you give me direction, and there may be a point, and I've done this with Katie. Katie knows it, where I've said, Katie, I need to cut you out of this conversation. I need
Yep.
the board, if I don't have the board's contact directly because she made the initial contact and maybe it's a new client and I don't know who the board is, I said, I need to talk to the board without you. And I'll go in and I'll talk to the board and I'll say, hey, board, I cut out Katie on purpose. It's nothing against her, but your interest and Katie's interest may not be 100% aligned. And
Mm-hmm.
here's why. And it may be an indemnity issue. It may be, heaven forbid, Aperion messed up
Mm-hmm.
and they're at fault in something, or they help trigger a problem, or maybe the association's at fault and has a duty towards Aperion, right? And we need to talk about how that gets sorted out. And so there are situations where we need to talk without the manager there,
Mm-hmm.
and we need to get into the nitty gritty of some of this stuff. And Katie's been great to work with over the years, and Aperion's been great to work with in those situations. And I know Aperion's attorney very well because I've had to deal with him on different cases, and that's okay. The privilege is set up to
Mm-hmm.
help navigate through these things where maybe you're 98 or 99% aligned, but 98 or 99% is not 100%. And we need to recognize that. And the same
Yes.
is true, by the way, with directors and officers, where we have to exclude certain people from those communications. Um, it's there's just a lot of nuance. So the
Mm-hmm.
point of this very long windup is that as you see this stuff start to come down the track, call the attorney sooner rather than later, because yes, I maybe none of the folks on this call are this way, but homeowners associations are notoriously cheap. They don't want to pay for a lot of things. And I get it. I live in one. I write a check to my HOA. But the privilege is a key piece that you want to preserve. And so if you talk earlier, you can preserve it without waiving a bunch of stuff you don't really want to um,
Yeah.
later on.
Well, and I think that we find just as a management company that these issues are better discussed really transparently and open because there, as you said, there's going to be things sometimes that, we may not see eye to eye on, but bringing in the experts and the professionals to deal with it from a fact-based perspective is always our, sort of the best foot forward in how we approach these situations because we have a duty to the association too, and we do take that seriously, and we want to do the right thing. But we make mistakes sometimes, and so it's helpful for you guys as board members that are on this call to understand the right questions to ask and how to navigate it.
Yeah.
So we're going to talk a little bit, about email. I think that when we talk about communication, there's obviously various forms of communication. You're not sending as many letters and, registered mail so much anymore. Email has definitely become our main form of communication, and that can be very convenient, but it can also be troublesome when you start to talk about potential legal issues that come up and how that impacts a community. And so one of the important things that we wanted to touch on today was sort of paying attention to how and what you're emailing. And part of this is gonna, obviously touch on, who should be on the emails. But also understanding sort of the process of what will be made available if an issue comes up. So, when we talk about email, the tricky dynamic to navigate in Oregon, and if you've been on our other board trainings, you've probably heard me talk about the perspective of an open meeting and how board members need to be very cautious about their email communication, especially if you're ever replying to all board members, because that really violates kind of the intention of the open meeting statutes in Oregon that allow for owners of your community to observe the debate that occurs. So we really would recommend that the board try to avoid conducting a lot of business via email, because it should be done in a meeting. Your managers are sort of doing the work, preparing recommendations, preparing information, taking care of actions, and then presenting it to you at the board meeting. And at the board meeting, you guys should be debating and discussing. So, when we talk about who's on emails, we want you to be very cautious about the communication that you're having. But additionally, if you've got a confidential issue, as Chris is saying, that is going on, and the board is discussing, do we want to meet? How are we going to address this? All of those things need to make sure that you are copying your attorney, that your attorney is part of those conversations that is taking place, that they're engaging in that communication so it is protected. But the piece of this too is you can't just be having a conversation that you don't want to violate the opens meetings law, so you're all of a sudden just going to copy your attorney on it so that it's something that you can try and keep privileged. It's not quite how that works. Your attorney needs to be an active participant or sort of engaging in that issue in order for that communication to be protected. And so who's on an email is something that you should be very thoughtful of. If you're sending a full email to the board, arranging a meeting, doing some operational things on like, hey, we're going to meet and discuss on this issue on this date, get questions to the manager ahead of time so we can be prepared. Those types of things are great. But if you've got an issue that's come up and you're debating the solution of it by email, understand that this is something that you may have to turn over if you have a legal issue that comes up, and discovery is necessary in that case. So make sure that you're not putting something in an email that you wouldn't want read in court. That's sort of our bar that we talk about with our managers. We also give them the scenario of like, don't put something in an email that you wouldn't want to wind up on the 5 o'clock news. It seems kind of common sense, but Chris and I have all, we both had those cases over the last 20 years where you get a copy of that email between two board members and you just cringe. Like, how could they have said this in writing? Like, don't make personal attacks on fellow board members or your owners or conjecture or gossip or rumors. Like, those are all things. Keep them out of email. Preferably keep it out of the behavior in general, but keep it out of writing, because those are the types of things that when a legal issue comes up, they request discovery on things that those then have to be produced and it becomes problematic. So I think if you consider things through that lens, it just helps you make sure that you're not going to put something in writing that Chris is later going to have to figure out a strategy to defend the stupidity around later on. And, understand that if there are email communications or there's, those types of things that become discoverable, what you want to make sure is that you're establishing processes for your community that are consistent. Because, that's where a lot of times things go sideways and Chris, gets hired to defend them is, the ARC was acting one way with this owner and another way with this owner. And there's documentation that provides that there was some deviation from the process. So just keep in mind that that written communication becomes the record of the corporation. And if there's something that just seems like, I'm not sure I want to say this, pick up the phone, whether that's to your attorney, to your manager, to your fellow board member, like pick up the phone, have that conversation. And if there's further documentation that has to take place by email, you can, but it's better to kind of err on the side of caution. And I think the other thing that we want to touch on with email, and Chris and I have had this conversation a couple of times, is if you are having a robust amount of communication and you're doing so from your personal email box, and a legal issue comes up, you don't want the use of that email to sort of crack open. Now you're turning over thousands of emails out of your personal communication because that's the mode in which you communicate. So there's sort of this growing thought or idea from both, Chris as well as other legal minds around the state that board members might want to consider having kind of a separate, email, that if you're serving on a board, you might want to set up a separate Gmail and, first, last name, HOA 2024 kind of scenario. And so you're segregating the communication to a separate email instead of your personal. Because I know, Chris, you've had some cases that just kind of like cracks open somebody's personal information in a way that they would otherwise not be very comfortable with.
Yeah. A couple horror stories here. I think now is the appropriate time. So I had a case that was going to trial about 15 years ago. And 3 or 4 or 5 days before trial, we got a request from the opposing attorney late in the game saying, hey, you haven't given us the individual directors' emails. We have been going through all of this preparing for trial, and they've all been writing from their personal email account. We want all of their emails. So we went to our board president's house to look at it. We were talking to her about this, and she said, I've got over 100,000 emails here. How on earth, between her different folders, her sent folder, how on earth are we going to do this? And first of all, the sheer volume, and I'm not exaggerating here, that's what she said. The sheer volume was mind-boggling. But to figure that we would have to go through those and look for privilege and deal with it on the eve of trial was beyond daunting. It was demoralizing. Plus, we were scared about what could possibly be in there. I mean, the reality is you should not be communicating with each other via email. Just because it creates all kinds of problems, even if you have fewer than a quorum of the board on the communication, so you're not violating the open meetings law, it creates all kinds of problems. And just putting me on the email, as Katie said earlier, doesn't solve the problem. It's got to be a confidential communication for the purpose of receiving legal advice. So as you guys are debating something and you put cmt@vflaw.com on the email thinking that that's going to cover it, that's not. You've got to be asking me. You've got to be seeking legal advice or clarification, etc. So the easiest way is to stop. Just
Mm-hmm.
stop communicating via email. But if you can't do that, then I recommend that the HOA get email accounts that then can get assigned out to the various members. So you're not using your personal email to communicate. And it allows the HOA to maintain those email addresses after directors leave. And then it goes to the next president or the next secretary or the next director. And then the HOA can keep those because the records requirements under Oregon law are that the official records of the HOA be kept and stored. And that way, your personal email no longer arguably becomes a record of the HOA. You just don't want that. Nobody wants to see the things that you're doing in the dark. We just don't, right? And in your personal email, we don't want that. But it can get exposed. Now, I'm going to stop with email. I'm going to move to minutes.
Mm-hmm.
Probably about close to 20 years ago now, I had a big construction defect lawsuit. And in the minutes, this board had put, our lawyer told us this. We are paying our lawyer on a contingent fee. Here's the breakdown. Our lawyer said this about our case. Boom, boom, boom. Well, the minutes are discoverable. I can't keep them out. So the other side now had all this information because they had put it in the minutes and hadn't sent it to me beforehand or hadn't sent it to the manager beforehand to edit. Or if they had, the manager at the time didn't recognize the problem. And so all of this stuff's out there. And a lot of times directors also say, well, our lawyer told us this, and they use that as a reason to justify what they're doing, the action that they're taking. And so they'll say it to members or they'll say it to an owner that they're in dispute with or just somebody off the street. Who knows? They say, well, our lawyer told us this, or based on legal advice, this. And guys, that's the problem. You're throwing that out there, and now the privilege is being waived because you are telling people exactly what you were told, and you're releasing the confidential communication.
Mm-hmm.
So let's go to the next slide because we're moving into this, right? What to say, what not to say, right?
Yeah.
I mean, go ahead, Katie.
I was just going to say, if you have a middle schooler, this will be a little bit funny to you. If you don't have a middle schooler, then some of the verbiage on the screen might seem a little foreign. If you have middle school grandkids, you might want to Google some of their funny vernaculars these days. But me and my marketing gal had a little bit of fun with this slide because we have middle school boys that just think these things are hilarious.
So you're right, though, with the meme. What's been seen cannot be unseen. Once you open the barn door and the cow's out, you can't close it. And so whether it's an email, whether it's in the minutes, whether it's in something that you say to somebody else, it's out. And it's problematic. Now, the next slide talks about what are the consequences? And the answer is it's discoverable and it arguably waives the privilege because remember, if it's privileged, they don't get to ask about it. They don't get to get into what the communications were, what was said, that information, the substance. But if it's waived and if it's deemed waived, then it's discoverable. And the discovery rules in Oregon are very broad. It's not just something that can show up in trial. It's anything reasonably calculated to lead to the discovery of admissible evidence. So that's a wide swath. I have a lot of room that I can play in when I start asking questions, trying to get to something, even if the stuff I'm asking about by itself may not be admissible in court. It may be excluded. That doesn't mean I can't ask about it in a deposition. It doesn't mean I can't embarrass you. It doesn't mean I can't find a way to get it there. And I may be able to get it in as it goes to credibility. So um, anything that's said now arguably becomes fair game. And
Yeah.
that's the thing we want to avoid.
So when does privilege extend to a manager? And I think this is so tricky, and it's going to be the lawyer's answer of like, it depends. Because, obviously, as Chris said earlier, it depends, did the board include the manager in the control group? Was that intentional? Was it something that the board was allowing for the manager to communicate in those confidential conversations? But I think what Chris and I are both seeing, and as we see an increase in litigation, it's happening across the country. If um people around the country that are in the same business as ours that are seeing an elevated amount of litigation in their communities, it's just happening more frequently. So as that happens, there's going to be, sort of new elements of this. And we are certainly seeing that there's more and more scenarios where plaintiffs are questioning the privilege and how it extends to a manager. And so, part of our goal today was to just educate you on understanding, when's a good time for your manager. If your manager is the one that is doing the majority of the tasks that may be a question for the litigation, then there's probably a really good argument that they should be part of that control group and be talking with the attorney and answering their questions and helping to sort of lean the information into the strategy around the association's case. But if the manager really wasn't involved and, this work was maybe done by a committee and there's not a lot of engagement with the board on it, there may be reasons to just not suck your manager into that and not require them to be deposed or to do those things. So it really does depend on the facts at hand and what is going on in that situation that you may or may not want to extend to them.
And a lot of times, out of an abundance of caution, I will say to a manager like Katie, I'll say, hey, Katie, we're going to executive session right now. I'm going to have you stay out so we can talk. And I may change that later on and have her come back in at a subsequent meeting or whatnot, but I may exclude her just to be safe. And a lot of times managers don't like that because they don't understand. They're like, I've been involved. I've been, this is what I do. I'm the one. But the courts look at it differently, and they look at a number of different factors, and we base ours on what corporate law says and how they treat corporations. And mid-level manager in a corporation may or may not be part of the control group. They may define it as just the board of directors and the CEO and CFO, right? I mean, courts look at these differently, and so we need to be aware of that early on. And directors may say, well, I want my manager there, and it may not be appropriate for the manager to be there. So I had a case. Well, I didn't have a case, but I'm aware of a case. It's made its rounds in our office, but we know the ruling out of Hillsborough, out of Washington County, where Washington County judge said, no, the manager is not part of the control group. And so anything that was said while they were present is not privileged. Doesn't matter if it was intended to be a confidential communication. It's not, because the manager was present at the time. And that throws a wrench in a lot.
So ask the question, and I think the other side to this is that we are spending a lot of time on our company side educating our managers on this process as well too, so that our managers know when to call the attorney, when to advise you guys of this, when to step out of these situations. So there's a whole other manager education taking place around this topic on our side too, not just the board education side of it.
All right, so let's go to waiver. What was that, Katie?
I said waiving of privilege.
Yeah. So again, another long definition. I included the entire definition in the statute and the evidentiary rule. A person upon whom the privilege is conferred, a person upon whom to confer a privilege against disclosure of a confidential matter or communication waives the privilege if the person or the person's predecessor, while holding of the privilege, voluntarily discloses or consents to disclosure of any significant part of the matter or communication. This section does not apply if the disclosure is itself a privileged communication. Voluntary disclosure does not occur with the mere commencement of litigation or in the case of a deposition taken for the purpose of perpetuating testimony until the offering of the deposition as evidence. Okay, so a lot of legalese in here. It's a little more complex that way, obviously, but the idea is that if a person who holds a privilege voluntarily discloses the information that was given or consents to the disclosure of it, then it gets waived. And the exception to that is if I talk to an attorney and they give me this advice, and then I go to another attorney and I talk to them about that advice, because that is a privileged communication. I'm talking to another attorney about the advice that a different attorney gave me. That's privilege. So the privilege still stays. But if I go talk to Katie, and Katie's just my friend down the street, and I say, hey, Katie, here's what the lawyer told me, I've now waived the privilege. It can be in writing, it can be oral, doesn't matter, you waive it. Now, technically, as the red lettering shows, that doesn't occur until trial and it's offered, right? It doesn't really come up until then. But that's not entirely true, because you can have a hearing dealing with it so that you can be deposed about it. If it comes up in a deposition that it was disclosed, then you can have it at the hearing. They can ask all the questions they want, get all the information. It may not be admitted in court at a later date, but it's out there and you know it's there. And you're like, oh crap, what are we going to do? How are we going to get around this? So it can come out earlier, even though the technical waiver doesn't happen until trial. And I had this issue, and I was in a trial down in Marion County, out of Salem, and we were in trial. And again, it was over minutes and about what lawyer had said, and it was in the minutes. And we had a full-blown hearing right in in day 2 of trial as to whether this evidence was admissible because of the breach of the privilege. And we had to brief it and argue it and do everything. And ultimately, fortunately, we won. But it was, and so it didn't have to be disclosed, but it was a really close call. And the irony in all of that was the president of that association who wrote the stuff in the minutes was a lawyer. He should have known better.
Sometimes lawyers make tricky board members.
Yes. Yeah. No offense if any of you listening are lawyers. All right. So
some of the consequences.
Yeah, as we mentioned before, it's discoverable. They get to ask about it. They get to find out about it, and you don't want that. So guard that privilege. All right. Last slide, Katie.
Last slide. So fiduciary duty. This is like our favorite, key phrase in this industry. Explain
so
how this ties in.
I want to add one thing about waiver. Okay. And that we didn't mention this, and it's probably the most important thing. We left the most important thing out about waiving. Who can waive the privilege? Okay. So go back to what we said 30 minutes ago about to whom does the privilege belong? It belongs to the homeowners association, to the corporation. How can the corporation take action?
Through the board of directors.
Okay. And how in the board of directors, how they take action? It's always a majority, right?
Majority. Yep.
Yep. Majority rule. So to waive the privilege, for the corporation to waive it, a majority of the board of directors has to vote to waive it. Now they can vote to waive it and give somebody discretion to determine if they want to waive it, right? So I vote to give the president discretion in this upcoming thing as to whether she wants to waive the privilege or not. They can do it that way, but it cannot be waived without a majority of the board waiving it. So that's actually how we won in the case in Marion County I was talking about. Was, hey, that person didn't have the authority to waive the privilege. Even if they wanted to, they didn't have the ability. And so the fact that the information's out there doesn't matter. Now we won. We got lucky. A different judge may not agree with us on that argument. But the reality is, because it's a corporation's privilege, you cannot waive it without a majority of the board voting in favor of it. And so it's important to remember, as part of your fiduciary duties as a director and or officer of the corporation, that you've got this duty of care and loyalty to the association to maintain that privilege, to keep it sacred, and to not allow it to be waived unless it's in the best interest of the association to do so. And frankly, whether you waive the privilege or not, that question you should probably talk to your lawyer about and get
Yeah,
legal advice about that.
always.
All right, Katie, anything else on fiduciary duties?
No, I mean, I think that just making sure, as I mentioned earlier, you as an individual director have a duty to the association, and you're welcome to go revisit some of our board basic training that talks about fiduciary duty in much greater detail. But you have a duty to the corporation. We have a duty to the corporation too. So I think that, Chris has mentioned this a couple of times throughout this presentation, that he represents the association, not the individual board members. And that's somewhat true for probably most of the individuals that you're engaging. We as a management company have a duty to the association. The lens in which we examine, situations is going to be what's in the best interest of the corporation, not necessarily the individual board members. There sometimes maybe situations where that misaligns, what the individual board member wants versus what we're recommending is in the best interest of the association may not be in sync. And so understanding the fiduciary duty and sort of our duty of care is an important element of this. This also comes up too, to understand if you do have litigation that you tenor to your directors and officers insurance and you have appointed counsel that comes in, most of the time it's not going to be the lawyer that's been working through the issue with you. If a lawsuit's filed and insurance is triggered, if Chris has been working on the issue for you, a lot of times you'll have another lawyer that will come in. Important to understand that lawyer really represents the insurance company. They've been hired to defend the association, but hired to defend the association on behalf of the insurance company. And so there may be times where we recommend as a management company or your legal counsel, if they're involved, to say, hey, there may be some deviating perspectives here, and you might want to keep your counsel in the loop on things because they represent the association versus the insurance company. Can be a little bit costly, and it depends on the issue, but there may be scenarios where those recommendations are made based off of the facts at hand and what we're trying to protect too. So understanding who those individuals represent and who their duty is to is an important piece of the puzzle.
Amen.
So we are just about at time, but I want to give an opportunity for anybody that would like to unmute and ask some questions. An opportunity if you're looking for clarity on something. If you have something that's really specific to your community, we may defer to say like, hey, let us look at your documents or something like that. But if you have a general question that you'd like to answer, feel free to unmute, and Chris and I are happy to answer. All right, I don't see anybody in the chat and I don't see anybody unmuting, so we can kind of let everybody go on time. Thank you so very much, Chris, for joining us this afternoon. We really, really appreciate your time and all of the great information. This is a important subject, so we appreciate you giving our board members some of your time this afternoon.
Hey, my pleasure, Katie. I want to give a shout out to Jessica as well for cleaning up the PowerPoint and helping me out with that. So thanks to you, Jessica.
Thanks, Chris.
All right. Have a wonderful afternoon, everybody.
Thanks, guys. Have a great day.